Well, hello there. You're back again. And today, we're going to look at another classic contract law case, namely Entores Limited versus Miles Far East Corporation. So if you're interested in contract law, then make sure you watch this video to the end. As always, all the sources are in the description below. So let's imagine the year is 1949 and World War II has just come to an end. There's a lot of rebuilding to do in London and the need for construction materials is high. So a British company called Entores Limited, which imports builders' hardware, sees a business opportunity. They want to purchase a large quantity of a special type of steel called mild steel. So they reach out to a firm called Miles Far East Corporation, who they know can supply them with a large amount of this type of steel. Miles is located outside of England. So the two companies negotiate the sale of the steel by means of telexes. And for those of you who don't know, telex is an early electronic communications system that worked much like an email or instant messaging service. It's kind of like an early version of the internet. On April 1949, Entores sent a telex to Miles in the Far East containing an offer to buy 100 tons of steel at £73 per ton CIF London. Now remember that CIF stands for cost, insurance, and freight. It's an abbreviation used in international sales contracts. The seller agrees to deliver the goods to the buyer on board a ship at the named port of destination, and to pay the costs and freight. This term is really important for the facts of this case. Later that same day on April, Miles sent back a telex from the Far East accepting Entores' offer. Unfortunately, however, after sending their acceptance, Miles had second thoughts about the deal. On May, almost a month later, Miles sent a telex to Entores saying that they regretted having to say that they would not be bound by any contract that purported to have been concluded between them and Entores on April. They went on to explain that their acceptance of the offer had been sent from the Far East during a period of civil unrest, and that they had not in fact intended to enter into a contract with Entores. Upon receiving this news, Entores brought Miles to the English Court of Appeal arguing that a contract had indeed been formed between the two parties on April when Miles sent their telex accepting the offer. However, Miles argued that no contract had been formed because they never intended to enter into a contract with Entores, and therefore their acceptance was not communicated to the offerer within the meaning of contract law. So the court was asked to decide where and when was the contract formed. Before looking at the judgment, let's first break down the elements of this case using the IRAC method. IRAC. The issue or issues in the case. Where and when was the contract formed? Did a contract exist between Entores and Miles? If so, where was that contract made? In contract law, an agreement is usually made when there is an offer by one party and acceptance of that offer by the other party. However, for an agreement to be legally binding and therefore a contract, there needs to be a meeting of the minds, an intention by both parties to create legal relations. What is the relevant rule or rules of law? The general rule is that acceptance must be communicated to the offerer. This means that the offeree must take some positive step to convey his or her acceptance to the offerer. Silence is not enough. However, There is an exception to this rule known as the postal rule. The postal rule provides that acceptance is effective as soon as it is posted, even if the letter containing the acceptance is delayed or lost in the mail. The rationale behind the postal rule is that once the offeree has taken a positive step to communicate his or her acceptance by posting a letter, it would be unfair to the offeree for the offerer to revoke the offer and prevent the formation of a contract simply because the acceptance did not arrive when expected. Let's move on now to the application of the law to the facts of this case. Was the postal rule applicable to telex messages? According to Lord Denning, Mr. Telex messages are not like letters in the post. He said that a telex message comes through as quickly as an oral statement. In a face-to-face conversation, if you say something and the other person does not hear you, you must repeat yourself. Acceptance is not good unless it is heard and understood. If the line goes dead halfway through the message, no one knows whether or not the acceptance has gone through. So in these circumstances, he said, the rule of law must be that acceptance by telex is only effective when it is received and acted on by the offerer. In this case, Entores sent an offer by telex to Miles in the Far East, and Miles sent their acceptance by telex to Entores in London. The question is, therefore, where is the contract made? Is it made in London where Entores sent their offer, or in the Far East where Miles sent their acceptance? The answer, according to Lord Denning, is that it is made where the acceptance is received. Since Miles sent their acceptance to Entores in London, the contract was made in London. Finally, let's look at the conclusion reached by the court. The court ruled that the contract between Entores and Miles was made in London, which is why the English court had jurisdiction to hear the case. The court also took the opportunity to clarify the law on acceptance by instantaneous communication methods such as telex. The court decided that the postal rule did not apply to instantaneous communications, but that instead the general rule applied that acceptance was only effective when it was received and acted on by the offerer. Let's now finish by explaining why this case is such an important one. This case is important because it demonstrates the flexibility and adaptability of the common law system. When the law is applied to new and emerging technologies, the common law can evolve and change with the times. This case also shows the importance of considering the intention of the parties when determining whether a contract exists. While Miles may not have intended to be bound by their acceptance, the court found that it was the only reasonable inference to be drawn from their conduct. Ultimately, the court decided that the best way to protect the reasonable expectations of contracting parties is to continue to develop the common law to keep pace with technological advancements. So let's move on to the follow-up questions. Why did the court reject the postal rule for instantaneous communication methods such as telex? Well, the court rejected the postal rule for instantaneous communication methods such as telex because it did not make sense to apply the rule in such circumstances. The court felt that the rationale behind the postal rule preventing the offerer from revoking the offer and closing the door to contract formation simply because the acceptance was delayed did not apply in cases where acceptance was nearly immediate. Instead, the court thought that the better approach was to apply the general rule that acceptance was only effective when it was received and acted on by the offerer. This approach, in their view, ensured that both parties had a reasonable opportunity to consider the terms of the agreement before becoming bound by it. Next, what was the significance of the term CIF in this case? The term CIF in this case was significant because it determined the place of contracting. The CIF term in the contract between Entores and Miles meant that the seller, in this case, Miles, agreed to deliver the steel to the buyer, Entores, on board a ship at a named port of destination. In this case, the port of destination was London. Therefore, according to the United Nations Convention on Contracts for the International Sale of Goods, the place of delivery was London. This was important for determining the jurisdiction of the court that could hear the case. Since the place of delivery was in England, the English court had jurisdiction to hear the case. Lastly, how did this case impact the development of contract law? This case significantly impacted the development of contract law because it established the rules for acceptance by instantaneous communication methods such as telex, phone, fax, and later email. Before this case, there was little authority on how the traditional contract law rules applied to new technologies. As a result, this case provided much-needed clarity for businesses entering into contracts in the rapidly evolving world of international trade. The decision in this case continues to be influential in cases involving instantaneous communication and the formation of contracts. So if you enjoyed this video, then please make sure you leave a like and subscribe to the channel. Until next time.